All right, welcome everyone. Thanks for tuning in to this episode of the Hawaii Retirement Show. Today's episode, we have Stacy Takekawa of Takekawa Law joining us. So it's a kind of a special episode here. I'm excited for it. We're going to talk estate planning. She is an estate planning attorney here based on Oahu, and we'll dive into a lot of different things around estate planning. But I think a good place to start is Stacy. I'll turn it over to you if you want to introduce yourself. Tell us a little bit about who you are and what you do.
Yeah, thank you. Thank you for having me. So I'm Stacy Takekawa. I'm based in Kaneohe, actually. So even, windward side of Oahu, but of course, servicing everybody.
Mhm.
I grew up here in Kailua, went to Kailua High School, proud public school graduate.
Right on.
And then I went to the University of Hawaii for law school. Um, been doing this for, gosh, little over 12, 13 years now. I have a 2.5-year-old son, keeping me busy. And so really it's work, mom, work again.
Yeah, yeah. Awesome. Very cool. Yeah, that's cool. I'm based out of Kaneohe too, but
Nice.
we're
Oh, yeah.
representing the Windward side pretty strong
Yes,
here today.
yes, yes.
All right, so I think a good place to start is and a lot of people probably already know this, but I feel like you can never talk about or at least touch on the basics enough, right? And the verbiage kind of gets people mixed up, even if you've been around it. And so it might bore some people, but let's just start with some kind of basic stuff of like, okay, what are the key documents that make up an estate plan?
So I'm glad you mentioned that because there are folks who even have estate plans and don't realize that they have all of these separate documents. A lot of people will say to me, I have a trust. And in the trust, and then they start talking about things that are not actually in their trust, but are part of their estate plan in another document. So the main documents are a trust, usually, will. So revocable living trust, revocable trust, all generally
Mhm.
the same thing, whatever it's called, living trust, will, last will and testament, just a will, pour over will, they're kind of all the same document. Um, Powers of attorney. So the financial legal document for if you become incapacitated. Again, these are all three separate documents. And then an advanced healthcare directive, which is for the medical decision making. So those are the main documents. There are smaller documents that also make up the plan, but those are the big ones, and they're four separate documents.
Gotcha. What is the document called? I guess it's called a couple different things, but it's not really even as far as I know, like a legal document, but for like last wishes or like burial kind of celebration of life kind of thing. Is there
Yeah,
a
yeah,
term for
yeah.
that?
There's a section of the law that refers to it as disposition of remains, which is like
Mm,
a
okay.
pretty macabre kind of way of putting
Yeah.
it. But so that can be in a separate document. It doesn't have to be. I include that in my wills. I think a lot of people do, but
Mm.
there are some attorneys who have it as a separate document as well. And that's more the legal side. Do you want to be cremated? Do you want to be buried? And where's your final resting place, or are you going to be scattered, things like that. The celebration of life, and do you want to have a party? And
Right.
I had one lady even say who she wanted to have it catered by, things like that. Those wouldn't necessarily go into a legal document, but are sometimes expressed within the plan, you know, more just sort of colloquially.
Gotcha. Okay. And then so we got the basic documents. But even then, I think there's confusion a lot of times between a will and trust and when do you need each and what does each, like what purpose does each document serve?
Yeah, there's a lot of confusion around this one. And so a lot of people will think, I have a will, so I'm good. I don't need a trust.
Hmm, hmm.
Or a lot of people will think, I have a trust, so I don't have a will. Um, if it's done by an estate planning attorney, if you have a trust, you also will usually have a will that kind of works as work, they work together.
Hmm.
If you just have a will is not valid to do anything for you unless it goes through the court process called probate that most people have heard of and don't want to be involved with. So people don't realize that just having a will does not mean that after you pass away, we take out the misconception is after someone passes away, because it's in the movies, someone opens the sealed envelope that has the last will and testament, and all the family sits around, and the lawyer or somebody else reads what it says. And this is news to everyone, and
Hmm.
it's a big deal. That is not something that happens, especially not in Hawaii. Um, I guess I should say it's not something that happens in Hawaii. Maybe it happens in other states, but the will can do everything that a trust does, but it requires the probate proceeding to do it.
Hmm.
Trusts then avoid having to go through probate. And that's kind of why a lot of people in Hawaii will want to do one, because they don't want to have to go through the probate process. Trust is one way to avoid it. And it's the most flexible, the most adaptable, and comprehensive way, I guess, to avoid probate, have control over your assets after you pass, and also for incapacity. So that's another thing that will sometimes come up.
Hmm.
Trusts are valid once you set them up. You sign the trust. We'll talk about it later, I think, but you fund the trust, you put your assets in the trust. Um, if you become incapacitated, your successor trustee is someone who can handle things in your incapacity. And then if you
Hmm.
when you pass away, they're still in charge or they take over again. The will, if you become incapacitated, you can't, your child or whoever you've named can't bring the will out and say, oh, I'm the person who's allowed to help with finances and other things. Wills only work once you pass away, and they only work for if they go through probate.
Hmm. Yeah, and I think another thing that some people worry about is, and I don't want to, maybe you could answer this better, but amending these things or changing these things, I think some people think it's a massive decision of like a, and it is, but like a, it's irreversible, right? But a lot of this stuff, as long as you are not incapacitated, it's not too difficult, right? To kind of change things around, right?
Yeah, it's always just a matter of fees, of course,
Hmm.
for it's usually um not as much to change, one simple part of a document. You just pay, I guess nowadays it would be maybe a few $100s to do a trust amendment, depending on how much you're changing.
Hmm.
Um, but that being said, there are a lot of clients that I I just know you can tell sometimes it was hard enough for them to get to the point of setting up the plan.
Right.
I'm like, have this say what you want it to say as much as you can. Think of backups, think of
Hmm.
what, we have plan A is what you want. But what if plan A doesn't work? Let's have plan B and plan C right now so
Hmm.
that, we're prepared for things that might change, because people don't revisit the documents. Usually, a lot of people don't revisit the documents, but you're right. It's not something that is set in stone. All of these documents that I mentioned, the trust, the will, the power of attorney, the healthcare, they can all be changed over time because circumstances change. People change, relationships change, people pass away, that you maybe had thought would be there to do your planning for, carry out your wishes after you're gone or something. It's like, oh
Hmm.
man, the person I named isn't here anymore, or moved to the mainland. That happens a lot too. I have
Right.
clients who like named their kids and then the kids are all gone. And so they thought, well, now maybe I need to name somebody else who's local to help if I become incapacitated. So long-winded answer to yes, you can change the documents.
Gotcha. And then one thing I wanted to bring up here that I think is another kind of often something that's misinterpreted or misunderstood is the role of beneficiaries. So wills and trusts, and beneficiaries, I mean for retirement accounts or different investment assets. So I don't want to speak as the estate planning attorney, but I want to set you up. So the you have your wills and trusts, and that's how you kind of uh, decide how assets are going to be passed along. But the beneficiary designation on retirement accounts, and we're talking IRAs, TSPs, 457, 403Bs, all these retirement vehicles. If you name a beneficiary, you don't need to go any further to mention it or put it into a will or trust because actually, even if you did, my understanding is, let's say in the will you said, okay, I'm gonna leave everything to, this my niece or nephew in the will, but the beneficiary designation says something different, maybe it's, a spouse or something, then that's going to supersede what's said in the will. Am I correct there?
Yeah. So payable on death beneficiary designations for you can do it for bank accounts, investment
Mhm.
accounts, you can do it for other assets. You can even do it for real estate. There are things called transfer on death deeds. So that's why earlier I mentioned trust is one way to avoid probate. Another way is a beneficiary designation for your property. All things that are possible. And if the caveat is if the beneficiary survives you and is
Mm.
around to receive it after you're gone, then yes, that goes first. So even if exactly like you said, you have your IRA going to your grandchild, but you have everything else going to your kids, your will says I leave everything to my kids. But if you put your grandchild on your IRA or something, that's going to supersede anything that your estate plan says.
Gotcha. Yeah, that's interesting. I'm not too familiar with the transfer on death for real estate with the titling. That's something I'll have to look into. That's interesting. Um, and then the other thing is you can so the trust is like an entity. So as far as while we're on the topic of beneficiaries, you can name a trust as the beneficiary because it's a non-person entity, right? I typically advise clients to avoid that unless you have a good reason. If you have a good reason, sure. And the reason I do that is the taxation of assets within a trust, they can get really complicated, and I don't want to get completely down that rabbit hole.
Yeah,
But
no.
it's just something to consider is usually you want a good reason to name the trust the benefit. Like for instance, I don't know what you could think of like what do they call it? Like a spendthrift
Yeah, so it's usually if someone's saying, especially in Hawaii, where I think there are folks who have a lot sitting in a retirement account.
mhm,
Um, Typical client, real estate, some cash, not much, and then like a lot in their retirement. And they have a child who they're worried is gonna mismanage it, whether, because they don't know how to handle things or because they have some sort of addiction problem,
mhm,
anything that's going on with the beneficiary, where they're like, if this child gets my retirement account, that's going to be gone in a year. How can we avoid this? I want them to have the money. I want them to be able to use the money, but
right.
I don't want them to control it. So that would be a situation where you can't then name your friend or someone else as the beneficiary of the IRA and then expect them to be able to use the money for your child. So you would name a trust. The trust
Mhm.
could be receive the assets. There's taxes and stuff that go on there that's
Yeah,
less advantageous, but you're going to have the security of someone else managing the account for your child.
gotcha. Okay.
I know I always defer to like the financial advisors, the accountants, all of that on retirement. Who should be the beneficiary of your retirement accounts? If you don't have a specific reason to not, to name someone other than the children or the niece, the nephew, an individual as the beneficiary, usually that's what I say too. Talk to your advisors. They will probably tell you under the tax laws now, it's
Mhm.
better to name an individual for the retirement accounts.
Right, right. Okay, and then now let's talk about roles within the wills and trusts and estates. And what I mean by that is another point of confusion. Again, it's just around verbiage. And I think people know it, but they still kind of get tripped up over it is the executor and the trustee. So if you want to kind of high level, what are those two and how do they play in?
Yeah, so and actually it's funny. Executor, I think also comes from TV, movies or something, or just, we hear about executors. Hawaii law does not use the term executor.
Okay.
So the person in charge of your trust is the trustee. So
Mhm.
when you set it up, like if I've set up my trust, there's three parties to a trust. There's the settlor or the grantor, person putting the funds in, setting it up. The trustee, person managing whatever's in the trust, and the beneficiary.
Mhm.
And so when for my trust, I am the settlor, I am the trustee, and I'm the beneficiary. When I become incapacitated, I'm still always going to be the settlor, but I've named someone else, my sister, to be my successor trustee. And while I'm incapacitated, I'm still the beneficiary. But if I pass away, my son is now the beneficiary. So the
Mhm.
trustee and the beneficiary can change. Settlor is always going to stay the same. And all of that's within a trust. Who
Right.
sets it up? Who's managing it? Who's getting the stuff from it? Those are the parts of a trust. Executor would be the person in charge of the will. So Hawaii law calls that a personal representative.
Okay.
Personal representative is a lot harder to throw around than executor. And if you really like personal representative, they're representing a person, like it's confusing, but
Mhm.
that's what Hawaii law calls it. So we all in the legal field, we just shorten it to the PR. So the
Gotcha.
personal representative is usually the same person as the trustee when you set up the plan, because the question is who's going to be able, capable, reliable, trustworthy to handle things for you from the financial side if you can't, whether you're incapacitated or you've passed away.
Mm.
That person is usually going to be the trustee or the successor trustee, the personal representative, the power of attorney, sort of those three roles.
Mm.
And that's how we refer to them, which role they're in, depends on what asset they're dealing with, usually.
Gotcha. And I think depending on the complexity, these aren't these aren't the easiest roles to be appointed to, right? As a trustee. I think some people uh might think I want to be the trustee because I want to be in charge
Yeah.
without really understanding, well, it could be a lot of work and a lot of responsibility, right?
It is like I don't think people realize, especially like in an instance where you've got three kids,
Mm.
in three siblings who are in a family, and mom and dad pass away, and the oldest one is the trustee and the middle one is the one who lived here and took care of mom and dad, and they're like, how come I'm not the trustee? I want to be the trustee,
Right,
and
right.
I know everything that's going on, da, da, da. And it's like, you know what? If you're the beneficiary, usually in that situation, we got three kids as a beneficiary, one of them's a trustee. These two over here are still going to get their share.
Right,
They
right.
don't have to do anything. They get to sit back and wait. So the waiting part is difficult for a lot of people. It's control, it's access, it's
Mhm.
information. But, going back to what you said, it's a job. And it can take years depending on the assets, depending on the complexity. I mean, it can take years, and in those years, it's hours and hours and hours
Mm.
of your life that just weigh on you. You have to file tax returns. You have to contact all these companies. You have to respond to any inquiries. You have to deal with the lawyers. You have to deal with the
Mhm.
accountants. So it's a lot of work. And so there are clients I've had who come in and they're like, I'm nominated as a trustee. My younger brother is an accountant, an attorney, he's more type A than me. Do I have to do it? Can I let him do
Mhm.
it?
Mhm.
So there's a lot of people who will pass it up because they see the writing on the wall and they don't want to do it because it is a lot of work. You have legal responsibilities, you have fiduciary
Sure.
obligations. I mean, it's no joke.
So they can though, right? Can they pass it on to, let's say they want to pass it on to a brother, or is there other means where they could just seek out somebody like you and say, "Hey, listen, I'm an electrician. I'm a little in over my head. Can you just, you know, I
Point
don't
me in the
I'm,
right direction. Yeah.
right, 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 right."
Yeah. So depending on what the trust says, usually, typically, uh, a person named as trustee, the electrician says, I don't want to do this, but if I can just get a little help, I think I can.
Right.
You know, they could definitely, trustees can hire professionals to help, attorneys, accountants, et
Mm.
cetera, but even they could delegate it to another person
Mm.
for a specific time, for a specific asset. They're still, at the end of the day, they are the trustee, but they're delegating some responsibility to someone else to handle some part of it for them. That's usually allowed. It's allowed under the law, but it can be limited by the terms in the trust. The trust could say, nope, I'm naming Stacy as my trustee because I trust her. I don't want
Mm.
anybody else touching this. So in
Right.
that case, no, the person would have to handle everything on their own. If there is a person named as a backup, for sure, I tell people if you're good with the next person in line, or if there is a next person in line and you don't want to do it, by all means, you can decline to serve as trustee.
Gotcha. Gotcha. And then so the personal representative, I guess we'll get into the next part is probate, and if you don't have these documents, and then So there is an instance when the court can appoint somebody as personal representative if there's nobody named, right? Or no, or let's say that person is no longer alive or whatever it might be, right?
Yeah, so the court, so for personal representatives, it's always going to be a court appointment because it's a will, and a will has to go through
Mm-hmm.
probate before someone is authorized to do anything. So classic situation, there was a bank account that nobody that either they didn't get in the trust or they named a beneficiary, but they only named their spouse as beneficiary. Spouse died before them. It was a joint account. Now both spouses have passed away. And now what do we do with this account? If it's over 100,000, so Hawaii has a threshold of 100,000 before there's a probate, and it's when you add everything up together. So if there's an account here with 25, an account here with 50, an account here with 25, you've hit your 100. It's not 100 at each institution.
Mm-hmm.
But once it's going through probate, if there's a will, you look at who's nominated as personal representative, and the court will say, okay, person A, where's person A? If they've passed away, you have to provide a death certificate. If they don't want to do it, they have to sign something that gets filed with the court that says, I don't want to do it.
Mm-hmm.
Sometimes it's maybe if it's an older will, parents named their friend or their sibling to serve. And the sibling, I mean, it can get complicated. The sibling could live on the mainland and now is incapacitated. So they can't sign something that says they don't want to do it. What do we do? So you just kind of have to show the court why person A is not involved, and the court will, you might have to do an affidavit, you might have to get a doctor's note. There's a lot of different things. But we get to, let's say there's person A isn't available, person B isn't available, and there's no person C. So now what do we do?
Mm-hmm.
Whoever the heirs are or the beneficiaries are typically have to get together and pick someone, nominate someone.
Mm-hmm.
So that's where you can have fights. Let's say it's that situation. Mom and dad had a will from a long time ago when their kids were small. They named their siblings. The siblings have passed away. So now we're at the kids, and there's two kids and they both want to do it. And
Mm-hmm.
now we're in court, so it just becomes then a fight for who's going to do it, or do they get court appointed to serve together and share the responsibility? Lots of different outcomes. If there's no will, the law provides who has priority to serve. And so there's a list. It's if there's a surviving spouse or reciprocal beneficiary, or trying to think if, yeah, that's like first. Then there's heirs. So if it's was there a surviving spouse? If not, then it's usually the kids. Again, it gets complicated if you've got blended families, second marriages. Are there kids from the spouse, from a prior relationship? I mean, it's a web when you really start looking at the law. It just depends on the complexity of the family dynamic. But essentially, yes, there is an order of priority, and the court will look to that and say, okay, who's first? And again, you can have people with equal priority, and it depends on who wants to step up, who wants to do it. If they both want to do it, if there's more than one person that wants to do it, that's what gets settled in the court proceeding.
Interesting. And then, so I'm trying to think back to my CFP estate planning courses here, and I can't remember. So if you have, so what you just mentioned, we're talking about wills. Let's say you have a trust and you only named one person as the trustee and they passed away and you never updated it. Is it the same type of thing?
Same type of thing. Usually the trust will say, I name this person as trustee. If they're gone and there are no successors named, then, I mean, typically it's a majority of the beneficiaries get to
Mm,
appoint someone.
okay.
Gets complicated where what if the settlor is still alive? They've named their spouse as trustee, but the spouse has passed away and there is nobody else named. Now what do we do? Because there's the only beneficiary is still that incapacitated settlor,
Mhm.
but who gets to nominate a successor trustee? And the answer to that is it depends, and it gets complicated.
Right,
Sometimes
right.
the agent under a power of attorney can nominate, but again, if they only named one successor trustee, that's probably also the person they named in their power of attorney.
Mm,
So you might hit a dead end there. You might need a court appointment of a conservator for that person, which is a whole nother thing. You might need there are court proceedings for trusts. So we've only kind of talked about probate as a court proceeding, but you can have a trust proceeding in court where you maybe whoever's wanting to step up, maybe it's a kid, maybe it's a friend, maybe it's a beneficiary who's going to get it when that person passes away. They can go to court and say, here's the situation. We got a settlor. We don't have a backup trustee. We don't have anyone under the trust terms who's able to nominate. So, or who's able to, say who's going to be trustee. So here I am in court asking the court to review everything, and I'm suggesting I be the person. And so the court will look at everything, notify anybody who might be affected, like the other beneficiaries for after that settlor passes away. I mean, this is why proper planning can avoid all these, wow, I never thought it could get this complicated. And
Right.
yes, let's try to avoid it.
Gotcha. And I guess it's a good reason to name, because you can name contingent trustees, and it's good to kind of not stop with just one person, right?
Definitely good to do. Definitely name as many as you want, as many as you can. As long as, and so I have people ask me that too. They're like, how many do I need? I'm like, it's not there's no number, because you also may have 5 kids and none of them are capable of doing it, so you don't want to just name them because they're your kids. You want to name someone who's trustworthy or responsible, good at communicating, going to be able to handle everything. So there's no magic number, but I tell people when they're setting up their plan, I advise my clients, however many deep you can go, the better, because you never know this, what might happen.
Gotcha. And then with Hawaii's probate process, I know it's hard because there's no like normal situation. Every situation is unique, right? But probate, it scares people. Oh, you don't want to go through probate. You don't want to go through probate. How long would you say just like an average estate plan going through probate would take? Is that too hard to answer because everyone is so different?
I mean, it depends, right? It's not too a simple, everybody's getting along. We're just here because administratively an account was left out, or we forgot about something, or there was no trust. We're just doing a simple will, but yes, everybody's in agreement. Nobody's fighting. We have the person who's nominated in the will, they're going to do it. Or there was no will and still everybody's all on the same page. Depending on some other factors, like you really could also, depending on how many assets we're talking about, like let's say it's a house and a bank account or something, you really could get set up to kind of have that all ready to go in even as little as like 6 months.
Okay.
There's creditor issues, there's tax issues, those kinds of things will play into how long you need to wait before that no one's coming out of the woodwork later and you can distribute everything to the beneficiaries, so there's factors like that, but at least getting set up to go get the accounts to be able to like secure the property, pay the property taxes, deal with, not losing the house, not starting a foreclosure situation, that can be like 3 to 6 months. The death certificate is a big part of that. You need a death certificate to really get things going. And it depends on how the person passed away. For unattended deaths, it can take 3 months to even get a death certificate sometimes. It depends on what's going on, at the Department of Health, I think. And it depends definitely on the circumstances of the person's passing, how long death certificates take. I'm amazed. I have some clients who come and say, like, it's been 2 weeks and they're telling me, oh, yeah, I have the death certificate. Thinking,
Right.
who do you know? How'd you get that? And then I've got people who are like, it's been 3.5 months and we're still waiting and the mortuary, it's coming. So yeah, as with some other things, I'm not sure who gets to jump the line, how the line works, but
Right.
the death certificate can add time to the timeline.
Gotcha. And then the cost associated with it, because that's the other thing people are afraid of.
Mm-hmm.
Is that based on, do most attorneys charge kind of based on a percentage of assets to navigate them through probate? Or is a lot of the charges that come along with probate, is some of that from like the court process and some of it is just, the hourly attorney fees? Or what goes into all those probate costs for people?
Yeah, I think that is a misconception that it's a percentage of the assets. And so some people might think, it's just the house and I don't want to lose the house or have to sell the house to pay for the probate or to pay
Mhm.
the government. There's a lot of people
Right.
who think the state or the federal government will get a portion if you end up in probate, and that's all not true.
Hmm.
Uh, I don't know. I don't know everybody, of course, who practices in
Right.
Hawaii, and especially not even who practice in the estate planning field, which is smaller.
Hmm.
Um, but I don't think I know of anyone who charges on a percentage of assets. Most are doing a flat fee or an hourly rate.
Mhm.
Uh, so a flat fee, I charge a flat fee. So it's essentially here's the cost for me to get you from where we are today to being able to being court appointed as the personal representative. Like that fee will cover all the emails, all the calls, any questions, any
Mhm.
meetings, boom. And that kind of helps clients because then they feel like, okay, I'm not gonna be up against a wall to a point where I need an attorney and then I don't know and it just keeps going. And then they're afraid to call, they're afraid to
Yeah.
ask questions because every
Right.
call
Right.
costs them money, everything. But there are some attorneys who say, like, well, I'm going to charge you an hourly rate and it's going to be, this is my rate and I anticipate it might cost you X. I anticipate it might take me X number of hours to do this. And so this would be the cost. But they're also preparing for what if a beneficiary comes
Mhm.
forward with an attorney? What if another person comes forward with like a different will or something? And it can go quickly where if I've said I'm covering your flat fee from here to getting appointed, and then all those things come up, I might be stuck with, well, this is gonna take more time than the fees that I'm collecting, but that's a decision that the attorneys make. But it's
Gotcha.
what I tell folks too is so even with the cost of estate planning, people are sometimes put off by that.
Sure.
Um, setting up a trust, setting up a will, setting up the documents, it can be a nice chunk of change. And so it's
Mhm.
like, that's a lot. So I tell folks, you're paying on the front end and you know what the cost is to set this up because your attorney has just laid it out for you. Or your beneficiaries are paying on the back end with the probate. And we don't know what the probate's going to cost
Mhm.
because we don't know when you're going to pass away. We don't know what the rates are going to be at that time. We don't know
Right.
who your personal representative or who your beneficiaries are going to choose to be their attorney. So that's the cost is based on attorneys. It's based on the going rates at the time,
Mhm.
not usually based on how much is in the estate.
Right. No, that's a good point. I think a lot of people are hesitant they know they need these documents, they know they need all this stuff, and it's like, oh, it's expensive, or they're hesitant with that, but I mean, it couldn't be any more worth it. You're protecting, everything you've worked so hard to accumulate throughout the years. But I get it, I get it. Same thing with the advising.
Yeah, it's like I get it. And so it's just a decision you have to make.
Right.
And I tell folks, the other thing that you gain on the front end with the knowing the cause, setting up the plan is that control and security because if you don't have the plan and the probate process kind of controls I've seen, so when I was first out of law school, I clerked for the probate judge. So I worked in the court where all of this was going on.
Mm.
So I saw how families just can fall apart over
Mm.
money, over sentimental things, over what I often would sort of sit back and look and think like, this has nothing to do with the money. This has nothing to do with
Mm.
the house. This is
Right.
because that sister told that brother he was no good, in 1995, and he's never forgotten it, and now's his chance to make everybody's life
Right.
miserable because of some interpersonal dynamics from back in the day. Sometimes it's also what I tell when I'm advising, the couple, the parents. I'm like, you guys are the police officers, for your
Mhm.
kids. You're the authority. When you're gone, like right now they all get along. Right now they say yes. Right now they're good. But when you're gone, they're not necessarily beholden to anyone anymore.
Mhm.
Sometimes it's their spouses. It's spouses who come in. It's the different needs of the kids at the time. Maybe someone's got kids in private school and they're thinking, well,
Mhm.
I don't want this house. I want you to say, there's just all these stuff that
Yeah.
comes in where if you haven't set up the rules and the plan and this is how it's going to be, and you're going to kind of leave it up to your kids or the beneficiaries on this end, it can spin out of control kind of quickly. So,
Mhm. Yeah, and it is a shame. I help people with money, and money unfortunately can bring out kind of the worst in people,
mhm.
and sometimes good people, can kind of get led astray by, money. And I think that's a good point that even if you think, well, everything would be fine, they're all good, my kids are good, just put it in there, and that kind of eliminates the rare chance that something happens and
Mhm.
somebody changes course and wants to take all the take all the gold coins for themselves, right? Okay. Let's talk about, so Hawaii is predominantly land rich, cash poor. I always say that because uh, you buy these houses which are on average much more expensive than you would elsewhere and compared to your wages. And a lot of people have all their equity or most of their equity kind of tied up, or their assets kind of tied up in their house. So does that present any unique challenges or circumstances? I know this is where probably the trust kind of comes in big time, is with most of your assets in the house, you really want to have that trust, right?
Yeah, I really think it's a missed opportunity when people don't put the thought into what's going to happen to that house. I met with a family yesterday where, the at the end of the day, they're going to have to sell it. And there's emotions in it. It's the house we grew up in, but the kids are all grown. There's two on the mainland. There's one here.
Mhm.
He has his own house. So this family house that mom and dad built, and he's telling me stories about they built the room in the back, and he and his high school friends, put up the
Right.
framing, all this kind of stuff. And you're like, if you haven't thought about what's really going to happen to that, you haven't planned for it, it can fall apart pretty
Mhm.
quickly, and then you lose it. And in Hawaii, who doesn't want to have the house in Hawaii
Right.
because it's unique, it's limited, and they're just such high value, sentimental value, money value, market value. The trust can really help you plan for what's going to happen after you're gone, because you
Mhm.
may have a situation where you've got competing interests of the beneficiaries. But
Right.
it's your house, if you want to set up the rules to a certain extent, a lot of people then say, well, I don't want to, it's their problem, let them handle it. I don't want to
Mhm.
control from beyond the grave, and I'm like, I get
Mhm.
that. So these are the discussions that we have with clients to really go over priorities. What can we do? A
Mhm.
lot of people don't know their options. A trust can really extend, I tell people it's an extension of you after you're gone, as far as what are the rules for the house, who you can set up a residence trust,
Mhm.
which says who gets to live in the house. If nobody's living in the house, can we have like a long-term rental? And then how's the rental income going to be split? You can set up a situation where you have three kids. One of them lives with you, the other two don't, and adults.
Mhm.
Um, Child lives with you, maybe with or without their own family, and then the other two are on the mainland or something, or just in their own properties. If you pass away and it's a three-way split, there's no guarantee that the one who lives there and it's their house, gets to stay.
Mhm.
Unless you can set up a trust that says, sure, if that's the situation, I want this son, I'm just three
Yeah.
sons, I want this son and his family to be able to live there. But if he's going to live there, he has to pay rent
Mhm.
to the brothers so that they get something. Or he doesn't have to pay rent because he's taking care of us in our old age, and we want him to be able to live there. We want his kids to get through high school at their current
Right.
school. And when that's done, then they can sell it. I mean, the options are endless for how to set it up so that you're not just going with three equal owners
Right.
who end up fighting and forcing a sale. Because I think that's another thing people don't realize. You cannot force people to own property together.
Yeah,
It's like,
that's what I was going to get to. So your example had three people. Let's say
mhm.
you had four, and isn't there sometimes there'll be some verbiage where they need to like agree or majority rules, and then could you end up
Right.
with like a 2-2
Yeah,
split? And
yeah,
what happens
yeah.
there then?
So, I mean, in the trust, you would cover all of this,
Mm,
right? If you're setting up the trust to say, I want my kids to majority rules agree. if
Mm.
we don't have, because you might not even have a 2-2 split. You might have a 4-1-1-1-1 split,
Right, right.
One wants to rent it, one wants to sell it, one wants to keep it, but everybody gets to use it as a vacation home.
Hmm.
One doesn't care,
Right, right.
you can have a lot of competing interests. So what do? You set up those rules, you set up timelines, I've
Gotcha.
done that so I mean, we're getting really specific here and
Yeah, yeah, yeah. So
I should have
sorry.
prefaced like none of this is legal
Right,
advice.
right, right. Yes, yes. That's a good. I meant to say at the beginning. None of this
Yeah.
is legal, tax, or
None of
financial
this is
advice.
legal advice or
Okay.
professional. This is just for
Yes.
educational purposes only, informational purposes only. But yeah, it's an example to me of the value of what people in my field do.
Right.
Because we've seen, we've seen the fights, we've seen the breakdown, so we're better equipped to help you think of scenarios that you never thought of, didn't realize that could happen, didn't realize I could put controls like that, didn't real, when I start going down this path with people, I can see the light bulbs come on.
Right.
And after a couple of meetings, they start going, well, can I do this? Well, can I
Mhm.
say that? And so a good estate planner is going to also think about the costs of that. Because sometimes it's, you know, I've got the 4 kids. The one I'm always like, there's always a kid that lives in the house. I shouldn't say there always is, but that's sometimes the concern that people aren't thinking about.
Mhm.
Um, I want him to be able to live there but he can't afford the property taxes. He's not gonna be able to afford
Mhm.
the costs associated with it. So, what do we do? I'm like, well, you can set up a fund if you have
Mhm.
liquid assets that you can leave behind to sort of carry that over. It can all be part of the trust. There's a trust account, there's funds in a trust that are meant to pay for property expenses, not other things. It's meant to pay for property expenses so that the house will be kept up and taken care of. And then whatever designations you made, whether it's at this child's death or after a certain number of years, because you want them to be able to look for a new place to live before it's sold. All of these kinds of rules can be put in place in your trust to cover the contingencies, to cover situate. I mean, you can't cover everything.
No, no.
Sometimes things happen, but you can be as prepared as you can be so that we've got family harmony because it's not up to them. It's not up to the kids. It's up to you. You've set the rules. They're just following it. So yeah, with the Hawaii multi-generational living, sentimental value in these homes, there's ways to preserve it and still set everybody up
Mhm.
to get their fair share. I hear people all the time, I just want to be fair. I just want to be
Right,
fair. And
right.
there's a lot of different ways to accomplish that.
Yeah, that just the as you're talking, I just think of how on the surface, the estate planning is very simple and straightforward, and it can get very complicated very quick. And I think it's a great uh, point to make and reason to seek out somebody like yourself or somebody you trust, somebody you can communicate with, somebody who's going to tell you those options. Whereas, you see in like there's the online you can kind of get these legal documents drafted, and it's fairly cheap and it's appealing, and it keeps it. But I think that's the downside. Is it keeps it very surface level, and you don't know what to put if you don't know the right question to ask. You know what I mean? And this is where like speaking with somebody like you really, really helps them.
Yeah, you don't know what you don't know. And I mean, I had a simple situation where it was an uncle leaving to 2 nieces, and one of his nieces had a special needs child. So everybody was like, when he passes, his house and his money is going to go to her so she can help to take care of her son. The other niece is well off. She's fine. Everybody like, yay, this is the plan. We're all in
Mhm.
agreement. It's going to be fine. So he did I think it was legal to him. Like he did an online simple sort of will. So it had to go through probate, but he put it in backwards where
Oh,
he thought he was naming this niece as the beneficiary, but he named her as the executor, the personal representative, and he named both nieces as the beneficiary. And because they didn't quite understand it either, and everybody thought the plan was going to go one way, they kind of sat on it for a while. So if a certain amount of time passes, the option for the second niece to say, oh, no, no, I don't want it,
mm,
for tax reasons, that option goes out the door. So now we've got 2 beneficiaries instead of the one, And in order for it to get all to this one niece, this person has to take steps that could be taxable to her. And, it just gets complicated.
Right.
And it's a simple thing with maybe he just didn't know the terms. Maybe, if it's only as good as the person putting it in. And especially with AI these days too, I've had a lot of people say like, can't I just start talking to the chat
Yeah.
GPT and be like, create a will for me that's compliant with Hawaii law. And,
Yes. Right.
they get something and they say, okay, well, now I want to add a specific thing for my car to go to somebody. I mean, you can do things, but is it gonna work? Is it gonna be valid? The
Right.
only way to really know that is to consult with a professional and definitely to get all the other options and all the other considerations. Most of those online things also only go through plan A. So again, we talked
Right.
about how plan A is plan A.
Hmm.
If there's anything that goes wrong, you could end up in a situation where, people, your cousins are getting something. You're like, what? Why are they getting it? I
Right.
never would have, obviously you're gone in that scenario, but the results that people just couldn't have imagined because they didn't consult with a professional who does that thinking for you, who has that
Hmm.
experience.
Yeah, and I battle this more than you do in my field because in financial advising or retirement planning, what I do, it's much more conducive to do it yourself. It's actually a lot easier than it would be, the legalese of being an estate plan. And I find the same thing in what I do is, and I think there's plenty of people who are competent and capable of doing it themselves. Until you get tripped up by a certain situation that you didn't plan for, and then things just get all out of whack, and then you got to search for somebody. So I deal with AI has made it's great because it does help people be better at doing do it yourself for advising and their investments and all kinds of things. But I'm selfishly in the opinion you can't be
Yeah.
a trusted person who can ask the right questions.
Professional advice from someone whose job it is to
Right,
know all of the things,
right,
that
right,
you don't know, you don't know.
right.
And even, I've run into situations where I think even, and maybe I shouldn't say this, but in the legal field, attorneys who are not trained, who don't have experience in estate planning, sometimes, and not all, but there are some who it's like, oh, it's just a form, and I'll just,
Hmm.
I know the legalese, I know who you're talking about, and I'll just kind of fill in blanks and get you to a result.
Hmm.
Well, it's a result, but is it a good result? So I've had situations where I'm dealing with probates or trust administrations for a will that was drafted by an attorney, but was not an attorney who regularly practices in estate planning.
Mm.
And it's just, I'm like, I don't know what this means. And, they use to my children, and then they put some names in parentheses, but it's not all the kids in the parentheses. So who counts as a child? It can get really weird really fast.
Right.
Uh, and so again, it's someone, Hawaii, there's actually an ethical thing. You're not allowed to say you're certified or
Mm.
specialize in a field.
Mm.
But you practice in a specific area, and so there are folks who transition to estate planning and have been doing that, maybe not their entire careers, but
Mhm.
it's just with the continuing education we get, the updates to tax laws and changes, like, as you know, like some people don't know about the changes to the retirement rules and
Mhm.
are telling people certain things. There are
Right.
some attorneys who don't understand what happens if you don't have a will. There are certain terms for what happens if, like, a child has passed away, then what? They use the wrong terminology, or they reference the wrong thing, or not the wrong thing. They reference something that's not actually what the client wanted, and nobody realized that. So
Mm.
I'm going on a tangent there, but it's
No.
an estate planning attorney who has experience in the field, um, will know about the options, all the things we've been talking about, much more than do it yourself, way more than do it yourself, and even more than an attorney who's maybe just doing it on the side for a friend or something. I have a lot of clients who are like, my will was prepared back in the day from my brother's friend was an attorney, and they just did
Mhm.
it for us as a favor. And then I read them the document, I tell them what it is. They said, oh no, that's not what we want. I'm like, well, it's what it
Right.
says,
Yeah.
So anyway,
No, you can't replace. Yeah, a trusted advisor, whether that's legal or whatever it is.
Mhm.
Okay, let's switch gears to power of attorney. And I bring this up because this is a question that somebody brought to my attention, and I didn't know the answer. And I know it varies, but when we're talking of power of attorneys and banks, and particularly power of attorneys and how they work with trust. So let's say you have a not to go down the all the different scenarios, but let's say you have somebody with a simple trust and the bank account, let's say it's a savings account, is titled to the trust. It's revocable, right? And then the daughter or son has power of attorney for her parents, who are the owner of this trust that own the bank account. Can they use their power of attorney powers to access, like, to work on behalf of like the trust? Or is there like a fine line where, I don't know, it has to be separated or something?
Yeah, so I can imagine a argument that someone serving as an agent under a power of attorney would act on behalf of the individual parent, let's just, on
Uh,
behalf of mom, and mom as the settlor of the trust, uh, they're going through that door, but
mm.
really, and again, sometimes it's, oh, well, my neighbor did that and that it worked for them.
Right.
That's exactly what they did. Well, okay, well, technically, if it's a trust account, like the owner of the account is the trust controls that. So you have to look at the trust. And if the trust says mom is the trustee, so long as mom has capacity. The
Mm.
trust will even say, what does it mean for mom to have capacity? Do we need a doctor's letter that says she no longer can make financial decisions for herself? Sometimes it's once all the kids or spouse and kids or just spouse, the trust can sometimes say who gets to decide when, for the purposes of the trust,
Mm.
mom no longer has capacity. Um, if that's the case, then mom is no longer trustee. And so the successor trustee is the person who has access to trust accounts. So mom, as the settlor of the trust, the person who created the trust, is not accessing her bank account that's in the trust as that settlor. She's accessing the account as the trustee.
Mm.
So only the successor trustee should be the one who has access to that trust account. It can get tricky.
Sure.
I've seen the argument in an instance from the other trying to get in through the settlor door, but no, it should be, if it's a trust bank account, the trustee has access. If the first line trustee, is incapacitated, then we go to the next one.
Mm. Yeah, and in my experience too is, I mean, the banks have to follow the law. You can't make your own rules, but each bank can have their own policies on and how they go about handling these situations where, like you said, somebody might say, "Well, my friend said that they just did this." And it's
Yeah.
like, well, maybe that was a different bank and this bank has different policies. They're
Mhm.
still abiding by the law, but they require, I don't know, different documentation or different something.
Yeah, and my favorite thing when people tell me, "Oh, my cousin this, my neighbor this," I'm like, "You do not know all the facts of that
Right,
situation.
right.
You know what they told you. They may not know all the facts. So every situation is unique. Every bank is unique. Every financial institution is unique. There's a law. The documents themselves are unique. Like I said,
Right.
where the trust usually says, what does it mean who's the backup? What does it mean to be incapacitated? Who gets to decide that? Maybe all of that was different for your neighbor's mom, versus
Mm.
you.
And that kind of brought up something that popped in my head is I don't know how common this is, or maybe I'm the only one that hears these stories, but like a real conniving, deceitful child who finds a way to manipulate and change the trust and take all the assets. But there's like safeguards in place to prevent a lot of that on like your end, right?
Yeah, so I mean, it comes up where, yeah, the plan was in place forever, everything was fine, and then the rogue child comes back,
Hmm.
from somewhere, or comes in, shows up, comes out of the woodwork, and weasels their way in and takes
Hmm.
mom to a different attorney than the one she's been
Right,
using for
right.
30 years. And then, a change is made and now everything's going to that child or that child's in charge, where they weren't before.
Mhm.
So it happens. The other attorney, our job as attorneys is to make sure that we have the meeting with the client, the person setting up the document, that we're comfortable that they have, it's called testamentary capacity, which just
Mhm.
means that they have the mental capacity required to create these types of documents.
Mhm.
So, and that because again, sorry, another tangent where, the question is, my mom forgets stuff sometimes, but she knows who
Mhm.
she can make this plan, but
Mhm.
I'm worried she's starting to get forgetful. So that's why I want her to do this planning, so there you can have the ability to create these documents where in another scenario maybe someone would say, yeah, no, you don't have the
Mhm.
capacity to do XYZ. That's a little in the weeds,
Yeah.
but back to the safeguards and all that in place. Yes, the attorneys have it. Sometimes what they'll do is it's not going to be an amendment or a change made by an attorney. The kid gets the piece of paper and, writes it out or tells mom what to
Mhm.
write, and then they sign it. And sometimes, so it's not necessarily even just incapacity where she didn't know what she was doing. Someone told her to. She wrote A. Sometimes it's fear of abandonment. It's this
Mhm.
kid is here taking care of me. All my other kids aren't here. They're not here to take care of me.
Right.
If I don't do what this person wants, are they going to abandon me? Am I going to end up in a home? Am I going to end up out on the street? What do I do? Um, so they can know what's going on and they're doing it under duress, I guess is how you would
Right.
say that. So there's a lot of different safeguards in place from the legal perspective, but not everything that the child does might go through an attorney. Um, that being said, is you can write on a piece of paper, I want my child to be in charge, signed here. You can go before a notary, who's
Right.
not always
Right.
an attorney, sign it, and the notary's job is just to say, who's this person? They say that this is what they want, and I'm just here to say, yep, they were here and they signed it.
Mhm.
Uh, and then that can get presented, and the validity of that then gets challenged.
Right.
But is the damage already done because it's not something happening after the person dies? It's a power of attorney or something that because you can pull, power of attorney forms. The law in Hawaii that about powers of attorney gives you a sample form in
Mhm.
the law. And so, that just has to be notarized. And so
Mhm.
people can sometimes do that. They go in, they access the accounts that are not in the trust. They change beneficiaries on retirement accounts or things like that
Mhm.
using that power of attorney. So it happens and it's not always, can't always undo the damage. But if there was duress, if there was fraud, if there was anything like that, there are safeguards in place to try to remedy as much as you can. But
Mhm.
unfortunately, it happens,
Yeah.
and some things are irreversible. I always tell people just keep track of your elders, just keep
Right.
track,
Right.
check in.
Yeah. For sure.
Not because, and not only just because you want to avoid that
Right. Right.
situation,
Right.
you
Right.
check in on them
Yes.
anyway.
Because you love them. Right.
Yes, yes, yes.
Yeah. Okay. Interesting. What about record keeping and because I'm sure it's quite common for somebody to draft these estate planning documents and then 20, 30 years go by, and let's say they either don't know where they are, or let's say they pass away and the children don't know where these documents are. Can you talk a little bit about like record keeping and what to do in those situations?
Yeah, so I think back in the day, things were recorded, with the state, or sometimes banks held things in their vaults.
Mhm.
So people think that there is a magical place where all of the documents and records are kept. Not so anymore. There's no requirement. I also have clients when I set up their plan, they say, okay, so you're going to file this and then I'm going to get a copy. And I'm like, no, no, no. My practice is to give back the originals. You have it. I have a copy. And, especially with like cloud storage and all these things these days, like I'll have it. But you're going to have the originals and it's up to you to, a lot of people think they have to put in a safe deposit box, but then that can create a problem too, because who has access to that safe deposit box if you pass away? Run into that situation where documents are in there, but nobody's authorized to get in there. So you have to do a little special procedure to get access to get documents and then do everything. Most attorneys, I think, give originals back to clients and keep copies. But if it's from 30 years ago, sometimes these are done on typewriters. We're not keeping that, or it's very early days of the computers and the word processing. So my first recommendation to people is like, we don't know where it is. I'm like, do you know who drafted it? Sometimes if there's a deed involved, like they put the house in the trust, the attorney's information might sometimes be in the deed. Contact them. Okay, well, they've passed away. They don't exist anymore. That firm doesn't exist anymore. I don't know what to do. Okay. If you can't find it there, we have recently, so the Hawaii State Bar Association, which is the Association of Attorneys, have sections and so subsections that we're members of. So there's a probate and estate planning section, and we'll get emails that say, hey, does anybody have the documents for Mr. and Mrs. Smith? They'll put the full names.
Right.
We're looking for documents. If anybody has any information, contact so and so. So it could be like, for me, I've been at several law firms. Maybe I'm the attorney who worked on documents for a couple, and now I've sort of taken that client with me along, and then they pass away. The kids might go back to the firm, and the firm might say, oh, we don't know, or we don't have that, so the email to the section, I'll see it and I'll be like, oh, those were my clients, and so now I can contact the person. That also doesn't always work. And so end of the day, if you can't, the typical situation is there's a property, there's a house, it's in the trust. Nobody has a copy of the trust. Nobody can find the trust. What do we do? So again, it's something that's going to require court intervention to say, nobody knows what this trust said. Nobody knows who would have been in charge. Nobody has any idea what it could have said. So we're just going to have to proceed as if there was no trust. So it kind of goes back to the probate and the laws about who gets stuff and who gets to be in charge if you don't do any planning. So it is important for people. I tell them, keep it in a place that, like in the office, in the, back bedroom, on the bookshelf. You don't have to keep it in a safe deposit box. I have like a waterproof, fireproof safe, in my closet that someone could steal if they wanted to, but it's just for documents.
Right.
Make sure someone knows how to get into things, make sure, and you don't have to tell everyone, just tell the person that you nominated. If it's in the house, sometimes a lot of people find documents after people pass away by just going through the documents in the house. Yeah.
Yeah, no, that's good. And that's I try to like I have a secure, like I pay for a service where I have like a secure electronic filing. And that's kind of like a benefit, at least I see it as a benefit to like my clients, is like I want to be that person where if they pass away, they can tell whoever, just go talk to Jason, he's got whatever, but if I'm not here, well then, you know what I mean? That there's always a further issue. Okay, I want to be cognizant of your time here. I appreciate it. We've been going on and on. Let's do a couple more questions and we'll wrap it up. One thing real quickly, what if somebody has like assets in another state? Let's say they live here, but they have a vacation home in Washington, Seattle area or something. They don't need to seek an estate planning attorney or draft different documents that are for assets in different states, right?
Correct. Yeah. So a Hawaii trust, your plan here can own assets in other places. And if you think about it too, like if you have like a Wells Fargo account or why is that the one I thought of? Bank of America, Citi,
Right.
anything like that, that's not a Hawaii asset, and that can be associated with your trust. So yeah, it's something that your trust can control assets in other states. You don't have to set up two trusts. You do have to transfer the property into the trust. You
Mhm.
can't just say, oh, and by the way, in addition to all this Hawaii stuff, I have a house in Washington and I want that to go to XYZ when I pass away. If the Washington house isn't owned by the trust, it's not going to work. So
Mhm.
sometimes an attorney in Washington is necessary just for the deed to transfer
See.
the property into the trust.
Mm-mm-mm. Okay. And do you do I'm just curious, do you do some of that like the deed entitling work for people as well? Like once they want to transfer the assets?
Yeah, so typically for clients, yeah, once we that's like the I don't help them with, and I think a lot of attorneys, it's like we can't go to the bank for you and put your bank accounts in, but we
Mhm.
can do deeds that transfer title into your trust. I do that for my clients for their Hawaii properties.
Gotcha. Okay, so let's see. I wanted to touch on common mistakes, misconceptions, but we kind of went over a lot of that stuff already. We talked about the DUI planning tools. Um, how often should somebody review or update? Do you have a time frame that you recommend? I know it's kind of arbitrary and it's
It
kind
is arbitrary. Yeah, yeah. I tell people definitely any big life events,
of sure.
kids start to get married, kids start to have kids, kids graduate college, for the younger families who are planning, you want to make sure when milestones are hit, and it's not necessarily that you're going to change the document. I also tell folks that I don't charge my clients who maybe I've worked on their plan 10 years ago and they call me up and they say, "Hey, can we just take a look at it and make sure it still works for what we need?" Sure. I don't charge for that review and like, okay, well, these are the people that we have in charge. Are they still around? Are they still who you want to do it? Um, Sometimes the change is, okay, well, we set this up when our kids were 10. Our kids are now graduating college and one's super responsible and we know that she could handle it. So we want to name her, we want to change the trust to put her in charge. So those kinds of milestones, I tell people 5 years, 3 to 5 years, just take a look at it. Put a note in your phone, think of the age you'd be when that time comes and be like, oh, on my 45th birthday, I better remember to bust out the trust and take a look.
Hmm.
Again, it doesn't mean you're going to change it. And it may not even be that you need to work with an attorney again. Just look at it, read it. The parts that you're going to be focusing on for as it pertains to your plan, and just make sure it's all still what you think it is and will still work. Laws change, tax laws change,
Hmm.
administrations change and change laws. So
Right, right,
all the
right.
things can happen that could affect what your plan was. Reach out to the estate planning attorney just to check in. Hey, nothing's going on in my life that's changed. Any law changes that I should be aware of that might affect me? Most attorneys will be reasonable with responding to that and not charging you to do so.
Mm. Okay. And then last one here to wrap it up is like finding an estate planning attorney. And in my industry, it's kind of a racket because the finance industry loves credentials and a lot of them, it's just I don't know. I'll leave it there, but there's a lot of letters and how do you know
A lot
you're
of
getting-
acronyms, yeah. A
what's that?
lot of acronyms, yeah.
Yes, right. And then for people, it can be a daunting task to be like, how do I find somebody? Okay, they're working with me, Jason. Do I trust Jason? Does Jason really know? Is there a better? Is this, and like you said, there's good and bad in every field. Um, I don't know if you have any insights for like how you can kind of sort through the attorneys out there to find somebody. I know word of mouth is obviously the best,
Yeah.
right? Because you have a friend or family. That's always the best route to go.
Yeah, for like most things, right? Someone else has gone through it, so they can vouch for the experience, their experience. Estate
Hmm.
planning is unique though, in the sense that, yeah, that person knew what was good for this nuclear family. You don't have a nuclear family. Do they know how to handle that?
Right.
Word of mouth is a really good, obviously, we're saying that's a good way to go. Everyone's doing Google searches, looking on Yelp, looking at
Sure.
reviews. Not all attorneys are everywhere on all those sort of things. But I also am a big believer in shopping around. I don't think that
Mm.
I'm not offended when a client comes in and says, I just want to be clear. I'm kind of just here to get a feel for this, hear about your fees, hear about your process, kind of get to know you, see if I feel comfortable. I have 3 other meetings lined up, or you're the fourth person I'm meeting with and I'm deciding. I'm not offended by that. I don't know that other attorneys would be, because it's reasonable. It's a lot of money you're going to be sending. It's a
Sure.
lot of personal information you're going to be sharing. It's a lot of financial information you're going to be sharing. You need it to be somebody that you feel comfortable with. Um, Experience aside, accolades aside, do you feel comfortable with this person who also may end up be the person helping your kids navigate this, right? Or your successors navigate this. So shop around, get word of mouth, get referrals. It's a good point too. There's realtors that know estate planning attorneys. There's financial advisors that know estate planning attorneys. There's accountants that know estate planning attorneys because we all, work together and bump into each other in our work. And so if you've got good experiences, the word of mouth can be through those types of referrals, not necessarily just the client referrals, right? Someone who's worked as a client, but someone who's worked as not a colleague, but having to deal with a real estate transaction or helping someone file taxes for someone who passed away and they had a great experience with the person's estate planning attorney. So there's a lot of different sources in the word of mouth referrals, but shopping around, I think, is underestimated in this field because it's daunting to set up a meeting with an attorney sometimes. I don't know that many attorneys who charge just to talk to you the first time. Some do, and so, maybe that's up to people whether that's something they want to do. But again, it's all an investment and making sure that you get the right fit at the end of the day. Because there's clients who walk in, I know we're not going to be a good fit for a variety of reasons, and so I know it's going to be in the reverse the same way. Some people walk in and it's just, I'm not going to be their vibe, so.
Right. No, that's good.
But
Okay.
before, I know we wanted to wrap up, but I
Yeah.
have some of my, I absolutely, especially to your audience, the mistakes that I see people make because they just don't know any better. Adding kids to bank accounts, because we're talking about who gets to access the bank account, the power of attorney, the trustee, whatever. What if I just put my kid on my bank account? I trust my oldest son, or I trust my middle daughter, she's responsible. She's not going to mismanage it. And when I pass away, she'll spread it out with the siblings. That's so common. And because people are worried, well, if nobody else is on the account with me and I pass away, they have to wait for a death certificate. And in the meantime, all those funds are frozen and nobody can pay for my funeral and things like that. So again, I give different advice for those kinds of scenarios, but people don't realize if you put a child on a bank account with you and they're a joint owner, their creditors have access to your account. Even though it's your account, you put every penny in there. Your child didn't put in a penny. It's not their money, right? But on paper, you just made it their money.
That's a
So,
good point. Yeah.
I mean, people really don't think about the creditor situation, the potential creditor risk, which is avoidable with the power of attorney and it's avoidable when you set it up in this other way. Sure, the downside is the waiting factor maybe, but you balance that out, or you set up a separate small account with that child for that purpose. You don't have them on your $100,000 savings account that is meant to split between your kids. Also, because let's say there are no creditors, you pass away, that child gets that account. It's not, okay, we'll just split it three ways and that means nothing for taxes. They're making taxable gifts potentially, which with the, with the exemptions and things like that, maybe no taxes owed, but it just makes it more complicated than I think people ever consider when they do something like that. Same with houses. So another way where they're like, I don't want to deal with a trust. I don't want to deal with probate. I'm just going to add my kids to my house when I'm 80. If I'm starting to think I'm going down the dementia road, I'm going to add them to my house so that when I die, they'll just own it. And people never think about the capital gains part of that, and so it's just all of these things. Consult with a professional because what you're doing might work to solve the problem you see, but you don't see the problems you've just created or the other just factors that will make that maybe not the best outcome.
Oh, I'm so happy you brought that up because in the back of my mind, I wanted to bring that up and talk about it, but I was like, oh, I don't want to. But the gifting of the house or the naming, I think I hear that question so often is I'm gonna put my child's name on the house or put so and so on the name of the house. And yeah, there's just so much. I don't want to go down it, but the step up in basis and the taxes around it,
Yeah.
there's definitely more options and a lot of times better options than going down that road.
Yeah, like you think you're saving in probate or trust fees, but the capital gains is going to be
Hmm.
20 times that.
Right.
Which again, we don't have to talk about, but
Oh yeah.
just to point out, like those are the two kids on bank accounts, kids on houses. just not always the best or can cause more problems than they're solving.
Gotcha. Stacy, thank you so much. I think this was great. I think our listeners will get a lot out of it. I would love to have you back on, but I'm not going to hold you to that. I know you have a lot going on. I could sit here and talk for hours. If our listeners have any questions, send them over, and maybe there's a chance we do this again down the road.
Yeah, no, absolutely. I'm also a big believer in education. I want people to make informed decisions.
Mhm,
So I will definitely even meet with people. People will say, I already have a trust in place. I don't know that I need to make any changes, but I don't remember what it's. Can you just tell me what this says? I'm happy to take those meetings and
mhm.
just because it's an hour out of my day, sure. But it's like, hey, is this really what you want? It's good. Okay, great.
Right.
Not everyone needs an estate plan. Not everyone needs a new estate plan. But if they don't know and they don't ask, how do they get that answer? And so I'm big on doing these kinds of talks, doing presentations, getting answers to questions. Again, there's some constraints with giving legal advice,
Sure.
attorney, but absolutely happy to help. Happy to have these conversations as many times as you want.
Okay, awesome. I appreciate it. All right. Well, Stacy Takekawa, I'll put some information. I don't know what, but I'll talk to you afterwards. Maybe I'll put something where if people want to reach out to you, I'll put it in the show notes and they can
Perfect.
reach out.
Perfect. Thank you so much.
Awesome. Yeah, I appreciate it. Thank you, Stacy.
Thank you.
The opinions and statements presented on this show are for general information only and are not intended to provide specific advice or recommendations. Never make any investment or financial decisions based on information offered on this show without first consulting your financial, legal, or tax advisor. All economic and performance information mentioned on the show is historical in nature and is not indicative of any future results. All indices mentioned on this show are unmanaged and cannot be invested in directly. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. Lastly, all opinions expressed by Jason Katita and any guests on the show are solely their own opinions and do not reflect the opinions of or are endorsed by Toba Financial. For Jason Katita, investment advisory services are offered through Toba Financial LLC, a registered investment advisor offering advisory services in the state of Hawaii and in other jurisdictions where exempt from registration.